One of the things we've said from the outset, and I've had to repeat in a number of different contexts, is the vast majority of people who are punished for crimes, who get criminal sentences, did not get that punishment as a result of a jury trial. However, trials are by definition and design something that is provided for by the Constitution in the Sixth Amendment. And they are very important in helping us understand at least the theory of how the criminal justice system works, and sometimes the practice too. Remember, trials are adversarial. So you can have a look at some of the outside material to get a little bit more information about this. But for right now, let's just remember that the first part of the trial would be the selection of the jury. Then the prosecutor would open with an opening statement. Defense will sometimes reply. The prosecutor will then present evidence and witnesses. Then the defense will do that. Each side can present rebuttal witnesses. Then each side will give a closing argument. Defense first, prosecutor last. So one of the take-homes is that the prosecutor opens and closes the cases. Then the judge will give instructions to the jury, and the jury will deliberate. And the jury is going to make the decision as to whether a person is guilty or not guilty based on the facts. So the prosecution and defense compete as adversaries, offering their view of what the facts are and what the relevant law should be. The judge has to make the decision about what is the applicable law to be followed, and also to tell the jury as part of that what they need to do to impartially evaluate evidence and what law needs to be considered by the jury. And then the jury evaluates the facts in the case. Hopefully you remember that in the Sixth Amendment, one of the things we learned is that the jury was meant to be impartial. Part of the Sixth Amendment reads that in all criminal prosecutions, the accused shall enjoy the right to trial by an impartial jury of the state and district where the crime should have been committed. And that takes us to the very important issue of jury composition, which is where most of the discussion about juries comes in law and in reality. Juries are asked to come to the courthouse from a jury pool. In other words, many of you have received a note in the mail asking you to serve as a juror. You're actually not necessarily going to serve as a juror, but what you are going to do is go to the court and be asked a series of questions to see whether or not you can serve. That process of asking questions is called voir dire. And in the voir dire process, the theoretical goal of both sides, prosecution and defense, is a neutral jury. But here's where I get to ask what I call the tooth fairy question. Do you believe in the tooth fairy? Somehow I'm guessing the answer is no. And I would say that theoretical goal falls into the same category as Santa Claus and the tooth fairy, because actually what both prosecution and defense want is a jury that is most likely to decide in their favor. In other words, not an impartial jury. However, because each side has some control of the process, as we're going to talk about in a moment, an impartial jury can be obtained. One of the big issues in getting to that impartialness is making sure it is representative, because you've probably heard the phrase having a jury of one's peers. The Supreme Court has often interpreted one of the requirements of an impartial jury as that a jury should represent a wide spectrum of the community. And a lot of the legal challenges to juries have evolved around the question of, is a jury representative enough? Now, the idea of having a jury of one's peers does not mean that if you are a vegetarian lesbian, that everybody on the jury needs to be a vegetarian lesbian. What it does mean, for a start, is that nobody should deliberately be excluded from the jury. Now, there are two big ways people can be excluded from the jury. The first is called challenge for cause, and the second is called peremptory challenge. The challenge for cause is relatively uncontroversial. This is the idea that either defense or prosecution might reject a potential juror in the voir dire process, which could be written or oral, by saying, we think this person might be biased in a particular situation. Sometimes they'll have actual reason to believe the person's biased. So if the defense attorney says, do you believe my client is guilty? And the potential juror says, hell yes. That's clearly a case of bias. But the defense attorney can also reject somebody, for example, by thinking they might be biased because they had previously been a victim of a similar kind of crime. Likewise, the prosecution can reject somebody not because of certain bias, but because that person has someone in their family who has been arrested or is in prison and might be therefore less disposed and less favorable to the state's case. So that's challenge for cause. Each side has an unlimited number of challenges for cause, because the goal of the impartial jury means that each side needs to be unlimited in rejecting people who might be biased. Now, they can't just reject somebody, and a judge can and will step in if everybody is being rejected on some clearly flimsy bases under the label of cause when actually there is no cause. And that is in large part how juries get to be chosen. The far more contested and controversial arena of challenging potential jurors is something called peremptory challenge. Although challenges for cause are unlimited, each side, defense and prosecution, has a limited number of peremptory challenges, and they may use that peremptory challenge to reject a potential juror without explaining why. And the idea over here is just like the idea of reasonable suspicion regarding law enforcement officers, an idea we saw a few lectures back, says that people who have experience and training in a particular area may be able to realize things the rest of us don't. The idea is that experienced lawyers representing defense or prosecution might be able to have concerns about a potential juror as being fair without necessarily that person saying something that clearly falls into the cause category. The problem has been that peremptory challenge has often been used to exclude people in ways that are based on kinds of exclusion and types of discrimination we don't approve of in our society, in particular the issue of racial discrimination. Before we continue with this tack of looking at peremptory challenge and racial discrimination, let's do a very brief bit of background history. One of the very first decisions the Supreme Court made in the 1800s after the Civil War was that people cannot be excluded from juries on a basis of race. And this is pretty remarkable, actually, because this was a time where Jim Crow was rising and segregation and racism were pretty matter-of-fact and unquestioned. Nevertheless, the Supreme Court said you can't exclude people from juries in the 1800s after the Civil War because of race. Nevertheless, for the next 100+ years, it was the case more often than not that people were excluded because of their race. Now, we might add a little footnote here that when we say people, up until about the 1970s, we're mostly talking about men because women were almost routinely excluded from juries. But going back to our race story, so consistent with this idea of the Supreme Court early on saying you can't exclude someone because of race, there have been a number of decisions over time that the Supreme Court took to reject practices that led to the exclusion of jurors because of their race or ethnicity. What about peremptory challenge? Well, in 1986, this issue came before the Supreme Court, where in a case called Batson versus Kentucky. And in this case, the Supreme Court ruled that if the defense attorney believes the prosecution is using peremptory challenge, because remember, you normally don't explain what peremptory challenge is. If the prosecution is using peremptory challenge to exclude people only because of their race, the defense lawyer can ask the judge to ask some probing questions of the prosecution. And if the judge determines that race is the basis for the exclusion, that is then unconstitutional. So what we see evolving out of Batson versus Kentucky in 1986 is a kind of exception to the peremptory challenge, where if there's a belief that race has been used illegally, then that is not allowed. Subsequently, Batson was extended in other cases to deal with gender, to make it apply to defense as well as prosecution, and so on. One of the reasons we talk about that Batson case is to signal the fact that 100 years after the Supreme Court said you cannot use race as a criteria in jury selection, it was still a problem. Sadly, although 1986 seems a long time ago, this problem of exclusion of people from juries based on race has not completely gone away. It has improved, and we're also sensitive to other issues like sexual preference, national origin, religion, gender, but it is still an issue. And we continue to be concerned with making sure juries are as representative or not. One of the ways this issue continues to be of concern revolves around the question of how many jurors need to be in agreement in order to find a person guilty. Most of you are probably familiar with the rule in the federal system and in most states that in order to be found guilty, there needs to be a unanimous opinion among the jurors. However, some states do allow for less than unanimity in agreeing that a person is found guilty, and the Supreme Court has accepted with various rulings that it is possible that there's a less than unanimous decision for juries to find somebody not guilty. However, in a world where people of color or people of smaller religious groups or immigrant groups are more likely to be a numerical majority in the population and therefore in the jury, and also are more likely to have a different opinion from a majority because they have experienced the world in different ways, one of the concerns is that numerical minority that might disagree with the rest of the judge might also line up with other kinds of minority status vis-a-vis the rest of the jury in terms of education, in terms of religion, in terms of race, in terms of age. So that remains a concern. A final point we want to note about juries is, although it is not legal in most states, and it's not legal in the federal system, juries have what we might call as a secret, or more accurately, a hidden power to vote against what the prosecution wants, even despite the fact that the prosecution has strong evidence, because they believe the prosecution's case is somehow unjust, or the law that the prosecutor is using is somehow unjust. We call that process jury nullification. It is pretty rare. Like so many other things in the criminal justice system, the history of jury nullification is very bound up with the history of race, but it's not only about race. So, for example, in some of the first trials of Dr. Jack Kevorkian, who used euthanasia, he was found not guilty by initial juries because, presumably, they felt that the law that he was being charged on was unjust, that people should have the right to die with dignity, even if prosecutors proved that according to the letter of the law, he had done something wrong. With that, we see an example of how juries can still be very relevant and will still be very independent. Despite the fact that defense and prosecution want to have a jury that favors their side, and despite the fact that the vast majority of criminal convictions are based entirely without a jury trial through plea negotiations.